You know, in the world of law, sometimes the most powerful tools are the ones hiding in plain sight. They're the ones you've probably heard of, but maybe don't fully grasp just how much punch they pack. Well, today, we're going to pull back the curtain on one of the most surprising of them all, the affidavit.
So let's start with a big question, right off the bat. Can a simple piece of paper, just a signed statement, really be powerful enough to shut down a legal battle before it even gets going? It sounds a little crazy, but as you're about to see, the answer is a huge, resounding yes. And it all boils down to a few really fundamental principles.
All right, so to really get a handle on its power, we've got to start with the basics. Let's break down what an affidavit actually is.
Okay, so put simply, an affidavit is like testifying in court, but on paper. The person who writes and signs it, they're called the affiant, is literally swearing under oath that every single thing in that document is true. And this isn't just, a pinky promise. It's a statement made under penalty of perjury. That means if you lie, you're in some serious, serious trouble.
But hold on, you can't just scribble something on a napkin and call it an affidavit, right? Of course not. For a simple statement to transform into a legally binding document, it has to follow a very specific set of rules.
There are 4 essential ingredients here. First up, personal knowledge. The facts have to be things the person knows firsthand. No gossip, no he said, she said. Second, it has to be relevant. The information has to connect directly to the legal issue we're talking about. Third, as we said, it has to be sworn under oath. The person has to formally swear it's all true. And finally, and this is the big one, it has to be notarized. That means you signed it in front of a notary public who officially verifies who you are. These 4 steps are what give an affidavit its real legal teeth.
So we've got the what and the how. Now let's talk about the where, because you'd be surprised just how many places these documents pop up.
Man, affidavits are pretty much the workhorses of the legal system. They are everywhere. You see them in civil cases like divorces or contract disputes. They're crucial in probate and estate matters, for things like identifying heirs. They show up in pretrial motions, business deals, property claims, even in small claims court, and for simple things like verifying your identity. Their versatility is just incredible.
But here's a really important distinction to make. For all their power, an affidavit usually can't take the place of live testimony in a full-blown trial. And the reason is actually pretty simple. You can't cross-examine a piece of paper. The right to look a witness in the eye and question them, that's a cornerstone of our legal system, and it's something a written statement just can't provide on its own.
And this, right here, brings us to the most fascinating part of this whole story. We know what an affidavit is, but now let's talk about what happens when an affidavit is met with nothing, just silence. This is where its hidden power really comes out to play.
Just let that one sink in for a second. An unrebutted affidavit becomes the judgment in commerce. This is a massive foundational idea in law. What it means is if one person puts forward a sworn, written statement of facts and the other side says nothing, doesn't challenge it, that statement can become the final, undisputed truth of the matter.
So here's the absolute key takeaway. In the world of law, silence is not neutral, not at all. If someone hands you a sworn affidavit and you don't respond with your own affidavit that challenges their points one by one, your silence can be seen as agreement. Your failure to deny their claims is basically treated as you admitting that they're true.
And hey, this isn't some newfangled legal trick. It's a principle built on ancient legal wisdom, maxims that have been around forever. Silence gives consent. He who does not deny admits. These aren't just clever old phrases. They are living, breathing principles in our legal system today. By staying silent, you're essentially walking off the battlefield and losing by default.
Okay, so how does this actually play out in the real world? How does an unchallenged statement on a piece of paper actually bring a whole legal dispute to a grinding halt?
This is the final move. Once an affidavit's facts become the undisputed truth of the case because nobody argued with them, well, there's nothing left for a trial to figure out, is there? This lets a lawyer go to the judge and ask for something called a summary judgment. That's a final ruling that ends the entire case right then and there without a full trial. Game over.
So there you have it. We've seen how a simple piece of paper, when used correctly, can become this incredibly sharp tool for establishing the truth and ending a legal fight. It's a powerful reminder that in law, what you say is obviously important, but sometimes what you don't say can change absolutely everything. So it leaves us with one final thought to chew on. If your sworn word could become the final judgment, what truth would you declare?